It is 7:36. Reports were released yesterday of documents filed in the Manhattan federal court accusing NYPD brass of issuing over 850,000 unnecessary summonses in the last 8 years to meet department quotas under former Police Commissioner Raymond Kelly. But what is more even troubling is that the evidence pointing to this corruption has allegedly been destroyed, gone.
Yeah, text messages and emails released show several higher-ups scolding officers for certain numbers not being high enough. So if it is found that there were bogus summonses issued, that the NYPD tried to cover it up, what could all of this mean? Well, joining us this morning is New York trial attorney Eric Subin. Good morning to you.
Good morning, guys.
So we are looking at some documents are out there. Some of these pictures of the text messages and emails are out there. And you hear, the commanders scolding people saying, hey, we need higher numbers. Is that illegal in New York state law? Is that a quota?
Well, absolutely, especially if these quotas are in place to sort of disadvantage indigent and minority neighborhoods. I mean, that's going to be a civil rights violation, and that's really the crux of this class action lawsuit that was filed against the city and the NYPD.
Yeah, 850,000 summonses. It sounds unreal, but it's over the course of 8 years.
Right.
So what is the due process when it comes to something like that? Can now I go and say, hey, this was part of a bigger plan and I was targeted as a motorist? Can you say something like that?
Well, that's exactly what this class action lawsuit is. They're saying our civil rights were violated because you guys had a quota system in place and you were issuing bogus summonses without any legal sufficiency. So the summonses that were issued 5, 6, 7 years ago, whenever, were all tossed out of court, but now they're suing, saying you infringed on my civil rights by sort of oppressing the minority communities by issuing these so that you could pad your own stats.
Yeah, we just saw one text on the screen there saying, hey, you missed your numbers by 30. Why didn't you get more seatbelt summonses there? So here's my question, right? Because basically the crux of this case is that there's all this evidence out there that's poof, gone. These emails, these texts, I mean, we have some, but the rest of it is gone. So in a case, if you don't have the evidence, can they still win? Or is it a situation where it's presumed almost that there's guilt because these emails don't exist?
Actually, that's the exact case. Like, these emails and text messages that were turned over by whistleblowers. They weren't turned over by the city's corporation counsel through the course of discovery. So because if the plaintiff's attorneys can show that this was destroyed evidence, then the judge is going to give the jury who's hearing the class action lawsuit a charge on spoliation of evidence, which would essentially say you can but don't have to assume or infer that all of the evidence that was destroyed would have completely supported the plaintiff's positions, which are that we were sort of targeted because we live in minority and indigent communities to be issued summonses so that the police could sort of pad their own stats and reach certain quotas.
What I'm curious about also is those emails between former Police Commissioner Ray Kelly and Chief Esposito. Apparently there's none to be had, or none have been turned over.
That seems pretty illogical that over the span of 5 or 6 or 7 years, Ray Kelly and Police Commissioner Esposito would not have had one single email with the word summons in it, because they ran a search through their emails.
Right, and there's nothing up.
None have the word summons, which seems sort of illogical to me.
So where do we go from here? That's what I'm curious about. Now that this class action lawsuit has been filed, is this now going to be a process of discovery, trying to find out where these emails are, how to piece together this puzzle, and then we can move forward from there? Because obviously this is a bigger case if you're saying that people in minority communities were being targeted. In fact, and that goes back to the Eric Garner case, stop and frisk, all of those policies that were in fact during Ray Kelly's tenure.
Well, with respect to the class action lawsuit, at this stage of that litigation, all of that should have been turned over by corporation counsel, by the city's corporation counsel. The fact that they didn't, and now it's been uncovered that there should have been some evidence, and this is some sort of evidence pointing to the fact that it was destroyed, is going to lead to probably sanctions for the city. The city could be fined. The city could have to pay the plaintiff's attorney's fees. The city could get the spoliation of evidence charge issued against them. And in sort of the worst case scenario for the city, they could have their answer stricken.
The whole thing stinks. Stinks to high heaven right now, the idea of all this stuff just not being there, so. All right, Eric, thank you so much for coming in. I feel like we'll be talking about this more in the future as this thing plays on.
Always a pleasure to see you guys.
Yeah. It is 7:40. Another couple apparently bites the dust. Okay.